Good evening, thanks for coming out. My name is Dennis Walter, I'm Vice Chair of the Campbell County Conservation District, Chair of the Coordinating Work Group, which put this program together tonight for you all. What this program is going to do is it's going to explain to you, or we're going to explain to you the rights under KRS 100, your right to farm, and the responsibility you have under that KRS along with the right to farm. Our guest speaker tonight is Mr. Clint Quarles. Clint's a farmer. He farms 400 acres down in Scott County. He's grain, cattle, and tobacco farmer. So he pretty well knows what he's talking about here when he comes to this. He's done this before, and he'll give us some good information tonight. We have some guests here, and I'm going to speed this along so we don't drag it out too long so we can watch the game. But we have our pretty much our county government here. We have Brian Painter. We have Pete Garrett, Steve Franzen, county attorney, Ken Recton here, and we have Cindy Mentor, who is from Planning and Zoning Center, has taken over Peter Clear's position. So she's our new Planning and Zoning person. So we welcome all our government officials here tonight to learn along with the rest of us. With that, I'll turn it over to Mr. Quarles.
Thank you. Thank you all for coming out this evening. If I appear spacey, it's because I have read more about this game tonight than any debate. One of the guys that I went to law school with is best friends with Matt Jones. And so I enjoy reading Matt's work. He has made me not a blogger, but I read blogs now, and I can tell you one thing about Matt Jones from a personal standpoint: he cheats at cornhole. He was on my team too. We were trying to cheat. We were not good at it, really cheating. Thank you for the kind introduction. For a little bit further into my background, I grew up in God's country, which is not here. It's actually much further down 75 in Georgetown. But my mother's family grew up here in northern Kentucky and had lived in several of the counties up here, so I'm kind of familiar with the area somewhat. Grew up through essentially the 4-H program at FFA. When I was in 6th grade, we had a guest speaker come in with all the things you could do in agriculture. And the very first thing that was on the Scantron, or the overhead that they put up there, was ag attorney. It was the first one. I thought, well, that sounds good. I would like to do that. So that's what I've spent my life preparing for. I went to UK for undergrad, applied to a bunch of different law schools, and then ended up going to UK. I was very happy to do that. While at UK, I met my wife in law school. She's a Dirty Vanderbilt fan. So tonight I think she'll be a UK fan. Now, I understand the county attorney's here, so I say this with trying to escape this county without a bench warrant when I'm done. Just because I am an attorney, and including my wife, doesn't mean I'm like most of the ones I've ever met. And if I answer your question tonight, we will leave ample amount of time for questions with maybe. That's exactly what people hate about attorneys. We're never yes or no. It's always maybe. But we'll talk about the reasons why. Maybe that'll become more apparent. When I graduated law school, I moved to Louisville, where we helped take care of my wife's grandparents. But my big job out of law school is I was a bankruptcy attorney. And while doing that, I had several former farmers as bankruptcy clients, and that left a very, very strong impression on me. A lot of their misfortunes were not due to directly their actions. There were some liability issues that were involved there, some bad business deals, but a lot of it were just accidents that had happened in one way, shape, or form, and they ended up losing their farms that had been in their family for multiple generations, wiped out. We'll talk about how to attempt to stop that a little later as well. And after that, my dream job with the state opened up. I'm one of a couple people in the state that exclusively practice agriculture law. It's great. I get to read law cases that have to do with ag from all over the United States every day for a living. And that it's just fantastic. It gives me an opportunity to read what's on the horizon for other jurisdictions, even outside of Kentucky. When I'm not doing that, I teach an ag law class at UK. It's only for seniors, so I don't have any of the ball players in class. Succeed and proceed, I think that's what we're supposed to say. Did have Darius Miller a couple years ago, and he was a nice kid. All of that, I just did pick up another farm, so I'm right at 500 acres. None of that is with my parents. It's all in the ground. So when I say I farm, I mean I'm out on my own. This is not piggybacking off of mom and dad, and it's tough. I understand the struggles that some of this stuff entails. And when I talk about safety equipment and relations with the neighbors, I farm around 3 subdivisions in Georgetown, and I tried to count one day when I was in my sprayer how many neighbors that I bordered who are non-agriculturalists, and I lost count at about 350, and my boom almost hit a tree, and I quit counting. Didn't have time to go fix that. Just to knock it out and get it out of the way, I'd like to talk about the fence law, just so we can say we've talked about the fence law and be done with it. That we could spend the next 2 hours on fence-related questions. I have done that before. If anybody's coming to the Cattlemen's Association meeting in Owen County next week, we'll have a long time to discuss that. Up on the screen here, I wanted everyone to understand where they can find the laws for free that are updated in real time in Kentucky. And so it's a very simple website to find and to navigate by numbers or by keywords. Keywords are a little bit tougher. This is lrc.ky.gov. So this is the official repository for all the laws in the Commonwealth. There are some book forms of these that are, legally speaking, the official versions, but they copy directly off the website. When you pull it up on the left-hand side, you can click Kentucky Law, and it's going to give you a few different things to search over. By and large, if you're hunting for something in agriculture, it's going to be under the KRS. The KRS are the statutes in the state. So if you remember, have children that have listened to the after-school special bill on Capitol Hill, when the General Assembly meets and passes a bill, that is what they become. They become a statute. We have a pretty rural legislative group in the General Assembly. Ag bills come up routinely in long sessions and short sessions. There are lots of big things happening in ag all the time. So it's not a dying industry when it comes to our people in charge, and that's a very good thing. Those are relatively hard to change. When we start talking about the who, the what, and the why in these in a little bit, you'll understand why it is hard to change a statute. Some of the fence laws that we have were codified in 1942. So that will be very apparent in a few minutes, and you'll wonder why they haven't been changed. Sometimes they don't want to open them up because they are difficult. And when you do open up a law, sometimes people can get carried away with it a little bit, and the fear of the unknown with what could happen to one overrides, well, it's not that bad, so they leave it as it sits. That is to be contrasted with the administrative regulations. We can start in the administrative regulations just so I can show you where to find it. We'll come into title, and pretty much everything in the Commonwealth that has to do with agriculture is found in 302. So it's everything. So when you sell tobacco, you've got a Burley referendum where they take a little bit out of your check, the check-off money, and that's where it's found. That's how you get to the check-off. Some of these things haven't been changed in decades. Others of these, excuse me, I change routinely. One of note, because you do have a lot of livestock here in Campbell County and surrounding counties, is that everything in Chapter 21, with the exception of 005, is brand new. This is the Livestock Standards Care Act. This was a big deal over the last couple of years. When I wrote these, I authored these things with the assistance and guidance of a commission appointed by the people in charge in our state. I was on the phone a whole lot with and was threatened to be sued by PETA, the Animal Liberation Front, Humane Society of the United States, the Animal Legal Foundation. So these are big, big things. This is one thing that we don't do well in ag. We do a lot of things great in ag. We go to meetings, we eat, and we talk about how hard farming is. These people, let me just tell you, on the other side of things, this is me taking off my governmental hat and being completely biased. These people are extremely well funded, and they do not sleep. They are coming after you in the traditional way of raising animals. And this is an attempt, or they thought, to find a way to chisel away at animal ag in the state. Again, these are my comments and not part of my normal daytime reporting. But you ought to read these things. They're not catastrophic. They're basic things that you should be doing anyway if you're raising cattle. You've got to go out and check them. You've got to provide medical attention if they need it routinely. They require sufficient feed and water to at least maintain their body scores and condition. Then I wrote in some things about, elderly animals, of course, aren't going to look like younger animals. Infections, but those kind of things are out there. This will become prevalent in the next few years when we have more challenges to animal ag. So if I back out, that's where you find everything else is in the statutes. You can click that, and I've got everything else pegged up here. A lawful fence. Now this is how you know this thing was made in the 1940s. We come down here, we can see that the last time that these things were amended and looked at. So in 1944, during wartime, the General Assembly updated these things. And so they set the definition of what a legal fence is. I was thinking about fence on the way in. Where I farm currently, it's relatively, I'd say relatively, with big quotation, relatively flat. I've got some really rolling ground. Nothing like what I just looked at coming up 27. I swear I think I saw a lot of people with engineering degrees constructing a fence up and down some of that hillside. And that's what I had growing up. We raised some cattle on pretty rugged terrain, and fencing was a challenge. I didn't have sticks of dynamite or anything else to make holes with where I needed a fence post, so you kind of made do. They decided in their wisdom in 1944 that a fence 4 feet tall was tall enough to keep cattle in. One of the fun things going to UK is they have really old pictures of 4-H winners throughout the years in Garrigus and you see some of these Angus bulls from the 40s, they looked like a barrel with toothpicks for legs back in the 40s. I don't think the cattle could jump back then. It just wasn't physically possible for them to do that. I don't raise cattle anymore. Part of the reason I quit is I live an hour and a half away from my farm. I have never, since I quit raising cattle, had anybody call me at 1:30 in the morning and say, hey, your corn's out in the middle of the road, can you come put it back in? I used to have those kind of phone calls all the time. The big thing that stopped me raising cattle was poor fence on the farms that I was renting then. And number 2, I got a really good deal on some Chianina cattle. Well, you know what Chianinas are? They're essentially kangaroos in cattle form. They're just acrobatic. They would have done really well in the Sochi Olympics. They're spawns of the devil. They're just awful, awful cattle. That's why they were cheap. I'd never considered needing 8-foot tall corrals to work these cattle until I had them, or nets over top. So when we look at this, we have to kind of look and think about what the fence law looks like currently, what it is on the books. This thing is ripe for being looked at by the General Assembly one day, and any change to this by the General Assembly, I'm going to guess, is not going to be favorable for farmers, because it is so one-sided right now that in fairness, I just cannot see this thing going forward in the shape with updates that we know are needed to defense law, but in ways that are still protections to ag. As we go through it, it talks about cattle guards and gates, and you can actually use hedges to account for part of the height on this thing. So when we back out, almost all the statutes start with the definitions page at the beginning. So in fence law, you have 3 main prongs. What is a fence, or what is a lawful fence? Now, I've told you what the definition is, and let me tell you what the court system has interpreted the definition of a good fence to be. The judge generally says, did the cattle get out? And the whole reason you're there is yes. And you say yes, and they say, well, that's a bad fence. Or the judge can say, did the cattle get out? No. Well, that's a good fence. It's a results-based inquiry by the judge. When you get to that point, it is all retrospective. You know the fence was good because the cattle didn't get out, or you know the fence was bad because the cattle got out. Now, I'm not saying it's you all, but every one of you all either have a neighbor or know somebody that their cattle stay in solely based on willpower. You all seen this? I mean, there might have been a fence there at one point. Maybe the cattle remember that they had a fence there at one point, but that's the only thing keeping them in. Lawfully, that is a good enough fence if it has kept the cattle in. You can't force somebody to build fence until you can get a declaration by the judge that the fence isn't good enough. That is the legal definition currently, maybe not how the judge would state it, but with all of the cases that have been published in Kentucky, that's what the judges have said. The second part to fence is who maintains this thing. And I bet you get 3 calls a week on this exact subject. It is the easiest rule to think about and apply. If you and I are neighbors, and you, for instance, say we have 1,000 feet of common border fence. Now, common border fence does not have to be a straight line. It can have zigs and zags, and it can look like they were chasing snakes when they built the fence. We find the linear distance wherever it's 500 on me and 500 on you. Once we have walked and found that exact middle spot, my legal advice to you is to drive a fence post there. You will need to find that exact middle again one day. Just mark it down. I have done this 3 times walking it with a neighbor, and we never sunk a fence post until finally we did it. Once we're there, if I'm standing on my property and you're standing on yours, as we look at each other, we're each responsible for the fence to our right. That is the fence law agreement in a nutshell. That is what the law says, short of the default, or that is the default setting under the law, short of a division agreement. And you can actually have a division agreement, and you all could be harboring under one currently. You could have bought the farm subject to a division agreement that happened decades and decades ago. These things, if you do have one, they can be recorded in the county that you live in. So that is something to be cognizant of. I've seen very, very few of these in my life, but there may be one out there. I will check your feeds. Yes, sir.
What if 500 feet to your right is down all in Big Gully, and everything to the left is all on ridgeline?
That is an excellent question. That is what we call the Clint quarrels. My side is always the crap side. Your side has 12 feet.
According to your paper, you're exactly right.
That's right. Nobody ever thinks they have it easy. So your side, not the part that I'm responsible for, 12 feet of topsoil, you can push a post in by putting your finger on it. It's amazing. My side looks like Lord of the Rings background. I mean, it's up and down. I've got to cross 3 creeks. It's pure bedrock right up on top. The law doesn't care. Your half is your half. For maintenance, we'll get into this in a minute about being forced to build. But that's just it. That is just what the law, a long time ago, arbitrarily decided. It's the same for everybody. But your half, that's your half to go maintain. Now, whatever it takes to build fence and maintain it on your half, maybe construction materials could be different. Maybe instead of even trying to get woven wire to flex that much, you string strands or do something. That's what you have to do. Waterway maintenance, if you have the waterways on your side to maintain, that's your crossing.
No, when my dad was still alive and farming, he said that you would, yes, to what you just described. However, the 500 feet on top of the hill would be split, and then the 500 feet in the gully would be divided again, and so each one would have a half of the poor and the good.
Now, that could be the agreement for a division of fence. I've told people, and if you want to leave tonight with anything else, I'll tell you this. If you ever have to sue your neighbor over a fence, you've lost. Even if you prevail in the case, you have sued your neighbor. And that is just not somebody generally you want to have real teed off at you. Because people tend to have really long memories when it comes to this. And the creative ways I have had reported to me that neighbors get back with their neighbors, it is not worth the headache on it. And you can be legally in the right and sue and prevail. I'm just saying that it's probably a bad idea to do that if you have another means available to you. Once you've done all you can do, a lot of times that's all you can do. I was just saying exhaust everything possible. What your dad may have had was a division agreement with the neighbor to split up the good and the bad on that. That's perfectly fine, but that's not the default setting in the law that there is currently. But he could have had a great relationship with the neighbor, and that agreement might have helped keep the harmony between the two. That's the agreement for the division of fence, and that's what the law dictates that you must do, regardless of your side. Now, if you have multiple neighbors bordering you, you have to find the middle of your common ground for each neighbor. The farm that I grew up on, we have 13 neighbors overnight. My dad, when I was born, bought a farm in Scott County. We're originally from Franklin County. We've been on that same piece of ground in Franklin County since 1792. Very long time. Dad bought a spot to start on his own in Georgetown, only had enough money at the auction to buy tract 1 at the auction. An investor out of Texas bought tract 2. We farmed that when I was real little until I was about 10 years old. Toyota came in Georgetown, and tract 2 was split up with 13 different tracts against us. When that came in, we actually had to sue a couple of those people to build fence, but all of the rest of the fence, we have a hodgepodge. So against one side with our 13 common neighbors, we have, in order, plank, woven wire, plank, plank, woven wire, barbed wire, plank, woven wire, plank. I'm missing a few there, but that's not 13. But that's what we have. It's a complete mix down the line. Doesn't matter. You're looking at each, the legal analysis is each individual neighbor against you requires the 50% rule. Yes, sir.
What happens if the fence is not on the property line? Say it's a foot away from it.
That is perfect. Everything that I'm talking about is for boundary line fence. If you have a fence on you by a few feet to avoid all of this, fence rule doesn't apply. Now, what could apply is if your neighbors, without your permission, maintain that other side of the fence for 15 years and they follow the other prongs, they may own that distance between where their property line formally stopped and where their new property line now starts. They have to file an action called quieting a title, but it's called adverse possession. There's 5 prongs of that. And that is a real thing. It doesn't happen all that often. At the legal clinic at UK, we never had one until a lady came in one day and had adversely possessed this lot, vacant lot next to her in Lexington. She wasn't going to fight these people at all next to her, but they plowed her garden under, or bulldozed her garden that she had on that property before she could get her tomatoes off. And that made her mad enough that she came in, and by the time she was done, she owned that piece of property next door. Again, all because of a few tomatoes. Don't sue your neighbor. Yes, sir.
You mentioned multiple neighbors who live next to a subdivision,
Yes.
and there is no fence. There are,
That was perfect. That's a perfect example. They were instantly overnight. I've got 13 new neighbors on where fence wasn't required before. Now, technically, when my dad bought the farm, there was a neighbor, but because it was farmed as a whole, we had agreed not to build or construct fence. But you're right.
so you decide you're gonna run livestock there, and you go ahead and put a fence up.
Yes.
They're not responsible, they don't have livestock. I do, so I want to put it up to make sure my livestock's down my property.
Yes.
I don't go after them. I want to put the fence up, I want to put the type of fence up I want.
You can definitely do the entire thing. But so long as only one of the 2 parties has livestock, you can force the non-livestock neighbor to build a fence.
All right, so.
That is why it is so one-sided. That's why, in my view, this will be changed.
I don't want to piss everybody off in the neighborhood that I live next to.
You're pissing. I'm going off. You soon.
I got this, but just to keep common ground, I want to put it in. Now, if I want to put that fence line in, can I put my post right in the center of the stakes that the surveyor put down? Do I need to step off and have my?
I would put it directly on the boundary
All right.
to avoid those fights in the future.
Okay.
I've even read cases where very well-funded litigants provide by far the most interesting stories to read. Because I do read a lot of cases now. My 2 favorite cases to read are when both sides of the V look the same. So when it's Adams versus Adams, that's a family fight. Those are great to read. Because you'll have people mad. There'll be 2 brothers mad at each other over some girl they both wanted to date back in high school 70 years ago. They don't have a thing to do with the case, but they'll work it in there somehow. And the judge will usually pick up and comment on that kind of thing. The other types of interesting cases are where both sides have it in their mind that they're going to make a point to the other. And it doesn't matter that whatever they're fighting over could be solved by $5,000. They'll each go spend $40,000 on attorneys to go make their point. One of those involved the plank on a horse farm, whether or not that plank on the post, because the posts were put with the side of the post exactly on the property line. And then the rough sewn board is an inch, and then they put a face board on top of that. So this person wanted the fence moved over 2 inches. Now they did not prevail. The judge just declared that to be de minimis, but the judge, to credit the other party who had spent thousands and thousands of dollars fighting this, made a division agreement pursuant to this, forced them to sign it, to say that if fence was ever constructed in the future or deconstructed, they would move the thing over. All of that work, the person that won the case sold their farm a year later. It spent, it was close to $30-something thousand to win this case, and the other side probably spent about the same amount. So the lawyers made a lot of money, and the fence didn't move. That's why people love attorneys. We figured out how to win that case. So you got that. Now, yes, sir.
Aside from that case you just mentioned about the board sticking out an inch over the property line, does the law make any provision which side you put, which side of the post the fence is on line fence?
No.
No.
Everything in the law, we're talking about the statutes, say that it has to be a borderline fence.
All right.
For our personal experience, for the plank, we've got it both ways. We've got the ugly side on them, we've got the pretty side on us. Well, what's the ugly side and the pretty side? I don't know. If the fence post is on them, I don't have to mow around it, so I like that. For the woven wire, we have the wire facing us and we have the wire facing them. Now again, if you get really into a fight with your neighbors on this, and you have the woven wire on their side of the post, any maintenance of that fence will require you, unless you're acrobatic and have a crane, to be on their side of that post to drive your staple back in on that side. And you're on somebody that probably is not going to enjoy you being on the property for maintenance of that portion of the fence if you have it. Now, if you have all this, or there was no fence to begin with, there's a procedure in here for how to declare the fence to not be a lawful fence. Included in this procedure is where you go to actually commence your action, where you go to sue the neighbor. And it's in district court, regardless of the amount of money. So that's kind of a neat thing in the law. The courts in Kentucky, for the two smaller courts, they have a money break. And the smaller amount of money is in district court. And over a threshold amount, you go to circuit court. It's just a break that's made. Here, they don't care about how much the amount of money is. District court is the court of original jurisdiction for this. And the judge is required to make a determination as to whether or not that fence is lawful. Talked about that a few minutes ago. It's lawful if it kept the cattle in. It's not lawful if it couldn't keep the cattle in. But what's interesting in the statute is once the judge determines that the fence is not lawful, the statute says the judge shall order a new fence built. So the judge has no discretion once he or she determines that that fence is unlawful. If you can prove that that fence is unlawful, you win. As much as you can win against the neighbor. Again, when the judge does that order, the judge can also order that instead of what's there, because most of my fence lines are grown up. That's where we throw things, rocks, other branches, things like that. I'm sure your all's fence lines are the same way. They grow up over time. Trees grow in fence lines. The judge can order the brush and the vegetation removed. The judge can even order who gets the brush and vegetation, so they can split up the piles and the root balls and that kind of thing. One of our neighbors, the one we had to sue, was so mad he wanted all that timber because he didn't want us to cut it up for firewood. And so that lawsuit took place in 1989. To this day, those root balls are still there because that same guy has tried burning those about every summer since then. So, but he fought real hard, and we did not push back on who got the root balls. We felt we were very generous in giving him all the root balls out of that joint amount of fence. So he's got that. So once you get the order to build, now this is where it becomes totally different than I think your comment on my side is always the bad side. The judge here does have the ability to be flexible. The judge can order, if it's that entire fence line that's being replaced, for the cost to be evenly divided. So even though your half, the easy half, wouldn't have cost very much per linear foot, the judge does have the ability to apportion the cost of the fence amongst both parties equally. So the judge does have that. There's two strategies on that. One is, if I've got my half, I'm going to go on and build it if mine's the easy half. And number two is you can come in and try to work out with the neighbor ahead of time. If the fence law is changed by a judge and not by the members of the General Assembly, that is how it's going to fail. That is exactly how a judge is going to shoot down the fence law. Probably for being unconstitutional is what I guess on it. And what I think will happen will be you'll just have the perfect parties come along, and one of the parties, the ones being forced to build a fence, probably will be a very sympathetic defendant in the case, and will probably not have the livestock. And the judge will just look at it and say, this is unconstitutional for me to force you to pay money for something that you get absolutely no benefit out of. And maybe it's a pensioner or somebody else otherwise on a fixed income that does not and will never have the disposable income to build a fence. I envision that as what will happen. That's just my speculation. With the fence, if they don't build their half pursuant to the judge's orders, you can go back to the judge, and the judge will allow you to build the fence and send them to bill. Now, if they don't pay their bill at that point, the judge will enter a judgment and then a lien against their property. And that lien is allowed statutory interest there. There's a statutory interest lawsuit in Scott County over a farm, and these two people are just so mad at each other, the one is never going to pay the other. And I think every year that rolls by, it's 18% is what they have. My bank account at the Georgetown Bank, I think I get like 1/4% a year, so 18% looks really good on money if you can do that. That is the fence law. That is what most people always like to hear about. We haven't even gotten to our conversation about negligence, liability, and nuisance yet. Does anybody else have a quick question about it? Yes, sir.
On that fence law, I just want to ask something about that. I have a neighbor, and they had no livestock whatsoever. We have at least 5,000 feet of common border. And you're telling me they're actually responsible for half of my fence?
Yeah.
They have no livestock.
Yes.
So if my livestock actually gets out and goes down there, I can tell, they got out through your half of the fence.
Now that's great. That is a totally separate concept than who owns or who's responsible for the fence, right? Whose cattle did the damage? Yours did. Here's another thing.
See, but they're not going to work on that fence because they have no livestock whatsoever, and they couldn't care less. And in places where there's no livestock, there's no fence between us.
That's correct. Now, if the cattle break through an otherwise lawful fence, you get to pay the damages. They were your cattle. Here's the fun part about it. The second time, all right, never mind. Here we go. For every subsequent trespass by the cattle of the same owner, double damages. So if your cattle break out and do $10,000 worth of damage, you have to pay 10 grand. For every subsequent, if you can get this in front of a judge and they apply it as written, the second time your cattle are out and cause $10,000 worth of damage, you have to pay $20,000. I'm telling you what the fence law is. What does reality start to look like
And
there?
otherwise, I'm still totally
You're
responsible.
still totally responsible.
No matter what you just told everybody.
You can force them to build. I can tell you that definitively. You can, through some maneuvers, you can probably force them to maintain the fence by going through means, judicially or through a letter or by mutual agreement. But if your cattle are in those pastures, you still have other things that can happen. I don't know if the weather is supposed to get too bad tonight, but you have trees that can blow over and knock that down. You can have waterways that the water gates blow out. You can have just fence getting weak or holes or deer traffic, four-wheelers, coon hunters, any of those things that can cause a break in the fence. You are still responsible for making sure your cattle are inside that fence. So now that I know that
So in other words, that stuff about you owning on the right and stuff, if you got cattle, the fence is yours. and they don't get
The
that.
responsibility for the cattle are always yours. I'm not telling you things that don't match up, but I'm telling you reality is always going to be they were your cattle. Let's look at how this looks too if we have a jury. If we have a jury of your peers here in Campbell County, increasingly what's that look like? Other farmers on that jury? Even if there are other farmers on that jury, what's the chances that you don't know them? Because if you know them, they're probably going to get kicked off the jury pool, the panel. So you're going to get people that know nothing about livestock that you're going to, number one, you or your attorney are going to have to educate them about their rights, responsibilities, that kind of thing. And then at the end, a lot of people see cattle or farmers or landowners as targets anyway. You all have assets that are out there walking around, and your asset that did some damage. If beef prices is what they are, if I'm that plaintiff's attorney on the other side, I'm going to work in how much these cattle are worth to that jury and try to, in some way, shape, or form, to the extent the rules will let me, inform them about your wealth that's out there in the field. And all I'm asking for is a little bit to compensate my client.
I realize that, but I'm just saying, you did all that talking about the fence law, and it's kind of meaningless.
It's frustrating. It really is. But ultimately, the cattle are yours. The fence is this other thing that's out there. But I do see what you're saying.
And I mean, because I've had some of these other run-ins and stuff, and they say you got the right to farm and stuff. But when it comes right down to it, you don't.
You absolutely have the right to farm, but
I know,
what I'm saying, sir, is
other kind of laws that kind of like
okay, but what about this?
supersede.
Just you, now let's take this back for a second, we'll talk about negligence and liability. Your cow breaks out, and anyone else in here, their kid, swerves to miss that cow, goes off the bridge embankment and dies.
You're in trouble.
You had the right to farm, absolutely, but you also killed this person indirectly. So, I'm saying the rights and responsibilities are still your cattle. That fence is this other thing that's out there. Because you're not required to even put your cattle in that pasture.
I know that.
It's a frustrating thing to be there. And the things that I'm telling you, I hope they don't come across as being totally incongruent with each other, but it's frustrating when you work with the margins we have in farming and you do all of this work to watch your dollars get slipped away through the lawsuit.
Okay, and that other thing that you was referring to before, about you taking the fence on the right, I have heard that before, and then an attorney actually told me that really didn't matter, that wasn't in the law. Is that actually written
Yep.
in there?
Your attorney was wrong. I love saying
I mean, it wasn't a deal over a fence or cow or getting sued over that.
that. Yeah. I'm sorry. You know, I should know what these things. Yes, sir. You have to fix your
Just fix the fence and that.
I'm not very good at highlighting stuff, but number 6 there.
Hey Clint, can you zoom in and make it bigger on?
That's a tall order. Yeah, wait a minute. Here's one that looks like this. No, that's as much as it is.
Right in the
I
center.
cannot. Oh, all right. More. I feel tech savvy, let me tell you.
The other guy.
Okay, it doesn't quite fit, but right there's what we're looking at.
I read it when you had it small.
The boundary line, which is on the right when facing the boundary from that landowner's real estate. So it actually is codified. Call your attorney up, tell him it's wrong, ask for his fees back.
It was an immediate. It wasn't, I wasn't hiring.
Good, don't hire that.
They were starting, but I had hired an attorney.
But it is actually out there. And believe me, I've done an immense amount of attorney education on this, because these things really do come up pretty infrequently in the law. It's not uncommon for a county to only have 1 or 2 of these every 10 years. And it varies wildly from jurisdiction to jurisdiction. Down in western Kentucky, where it's predominantly grain farming and there are very few cattle, they sue each other left and right over this all the time. And then up here where we actually have a lot of cattle and a large number of neighbors, because our farms are so much smaller, we don't generally have them. It's kind of backwards in my mind where your volume of business would be on that. That is an excellent segue. In a minute it will be. Yes, sir.
I got 2 things.
Okay.
1, creek between farms with the property line down the middle of it. The other is road frontage and the neighbor across the road. And I had a 500-pound calf cost me $10,000 because somebody hit a tree.
Yeah. All right. $5,000 calf.
A $10,000 calf.
10,000.
He wasn't that good.
Number 1 on the creek. Creeks in common, when it does have a common border, does lie in a waterway, a pond, something like that. There's virtually no way to get around those other than some sort of gentleman's agreement between the parties. Because it is impossible for you to build a standalone structure that has a berm or a pillar or something like that in the creek to hold up your path. Good luck. I don't know. Because as an attorney, I say that all the time. I'm very quick to tell somebody when I don't know. Let me go look it up. I don't know. I've never had a case on this where the judge didn't, and that's only been in a couple cases, where the judge didn't lean on both sides so hard and essentially made them come up with a division agreement, at least for that portion. Because they are so hard. Creeks and waterways, they're just hard anyway. And that's just a hard thing to even physically construct that's going to last any amount of time, let alone worrying about where the posts are going to be set or something like that on the other side. Road frontage is a great question. This is actually an evolving area of the law. Typically on a county road, you all know what you all own by your deed or by that creek.
Mine says the center of the creek, mine says the center of the road, but I know that's not the case with the road.
Well, you do. If it is a county road, in some state roads, a lot of state roads, you own out in the middle of that road. Very inconvenient to build a fence in the middle of those things. So you have mandatory setbacks that varies not only by your county, and that's where zoning and some other local ordinances come into place, but the state actually load rates roads. Are you all aware of this? If you're all hauling something really heavy and you're subject to the DOT, they will enforce this, although Kentucky is way behind compared to places like Minnesota, Wisconsin, where they have actual bridge laws. We might have a bridge law in Kentucky in the next couple of years. Ohio, yeah. Well, that's right, you're all so close to Ohio, yeah. They enforce it, we don't. But depending on the type of road that is your road frontage, there are mandatory setbacks and that are minimal setbacks. You can have additional setbacks depending on curvature, ingress, egress, and what's on the other side of the road. You're pretty much on your own about building your road frontage with that. Now, if your road frontage is a limited access highway that the state owns, the state is like any other land owner at that point. The state's generally pretty good about that. Railroads, there's a whole section in this about railroads. They get treated with the same half and half, although railroads typically pay for all of it because it makes their maintenance on the other side, the track side, a little bit easier there. Your $10,000 calf might also be a good segue if we don't have any more cattle questions. All right. So we got an hour. I want to be home. You're all hurting my bourbon and ginger ale consumption because I don't need to do with this game are more like they have been. I want to talk to you all, and at least one of you in this room has heard this before, about a mythical person that the law is going to judge you against. You're going to love this one, in terms of the mythology of the law. In negligence, the law in the United States and the law in Kentucky in particular judges your actions if you ever cause an accident against somebody called the reasonably prudent person. This goes back to law school. You probably can remember writing some essays about this in a torts class. What the reasonably prudent person is essentially what you should have done. The law is always going to judge you against what you should have done. I have thought and thought and thought over my life about how to make a better example than going out and getting in your car, but I just can't. So what would the reasonably prudent person do? When I'm done, I'm going to go get in my car and I'm going to go drive back to Louisville. Now, the reasonably prudent person, before they even get into the car, is already thinking about that. And before you even get to your car, you're going to remember, yeah, I'm on a maintenance schedule with my brakes. I still have at least, 30 seconds of tread on my tires that I'm required to have. I know that I've changed my oil recently. I know I've done all of this maintenance in my car because all of you have that in your mind right now, right? Before I get to the car, I'm going to glance at all 4 tires. As much as I drive on the interstate, I actually try to do that every time I get in and out of a car because otherwise my next notice that I haven't checked my tires is a thumping noise as I'm trying to go down the road very fast. So I'm going to look at all my tires before I get into the car. Before I even turn the key, I'm going to look at my mirrors. I've not adjusted the mirrors in those cars in 5 years, other than to look for a flat tire going down the interstate. But I'm still going to look just in case somebody hadn't gotten in it while I was here and messed them up. I'm going to do that. I'm going to start the car. I've already looked for children, cats, things like that. I'm going to run over and back up. All of you all are doing these same things when you go home, right? We're not just getting in the car and heading home watching the cats play.
Sure, whatever you say.
When I drive this car, my hands are at 9 and 12 or 10 and 2. I think it changes all the time. But it's there. Am I listening to the radio? Maybe, but at a reasonable volume. I'm not driving angry. I'm not driving upset. I'm not driving tired. I'm fully rested every time I get in the car. I'm doing all of those things. Am I speeding? Absolutely not, but I'm driving the speed of traffic. I'm not inhibiting anybody around me, but I'm absolutely not speeding. And I'm driving in a manner where I'm not swerving or doing anything else. I am just, on my game. I'm doing all of these things. And this is what everyone in here does every single time, right?
Sure.
Nobody in here has ever gotten into an accident. I can tell you about my last several accidents. The last 3 of my accidents have involved me looking at other people's tobacco and corn. I hit poor old ladies in minivans routinely looking at corn. Look around the roads every fall in your county. And when we get away from the car example and we start to talk about ag on the reasonably prudent person, it might be a pretty lofty goal to act like that, right? But that is exactly what you expect of other drivers. You don't want to have lost your life or have somebody in your family lose their life because some other guy was running around on a bald tire, and when it blew out, it veered over enough to clip their car and send them off the road. You expect other people. I don't care if you were upset about your bad day at work. Calm down. Don't go turn your car into a missile and hit somebody. That is what you expect of others. When I'm moving equipment and I get singular finger waves from people because of my speed, Am I responding to them? I don't do any of these things. Now, as farmers, has anybody not ever lost a bale of hay? Has anybody ever, on the road, yeah. Has anybody ever lost a round bale? Watched that happen this past fall. Watched a guy pulling out of the road I live on. Decided he was going to move hay without a round bale on top of his gooseneck. They were stacked double tall, and it fell off. It almost hit a lady in the intersection. 1,500-pound roll bale coming on top of your car is probably going to be a bad day. Let's think about how the law would evaluate that. And about 2 weeks later, I saw a guy lose 2 bales at the bike. That was fun too. I mean, 2 600-pound bales at the bike. If I could have been out there with my loader tractor fast enough, I would have had them on my truck. How do you lose that? And what is the law going to do to somebody like that? When you get into court, I'm sorry it's not going to be enough. They're going to judge you against that reasonably prudent person who was driving the car, but they're also going to say, was the damage that was caused foreseeable? Can we foresee that a really high load with no strap on it, it is foreseeable that that load could fall off? Very. How much does a strap cost? $10 maybe? So for $10 you could have prevented killing somebody. And that's how the law is going to look at you. And when you think about it like that, forget that it's you and you're the farmer. But if you were the person harmed, or if that was your wife or your children that were killed, they were killed because somebody didn't take the time and the $10 it took to put a strap around something. Well, the strap broke. Now, how old was that strap? It's pretty old. Got a couple tears in it. And that thing's rated for like 15,000 pounds. It's about half chewed up, so maybe 7,500. Had that happen. Everyone in here has seen this happen. You don't know what an R key is. That's the actual name for it. I didn't even know that things had a name. The R key gets its shape because that's that little pin you're supposed to have in your hitch pin at the bottom. When was the last time you went down the road without that little R key in the bottom of your hitch pin? All the time. Who thinks about that? I have a buddy, Willis, who farms in Tennessee. Willis is a constant source of stories for me. Willis, in college, he cannot remember a class that he had, but Willis took care of the hound dog that is the school mascot for UT. He can tell you about that. That's about all Willis got. Willis farms 5,000 acres right on the Kentucky and Tennessee line. Y'all ever seen the state map? It actually dips down. That was Willis's ancestors. They didn't want to be in Tennessee, so they helped move that. And then he always says, but then, my dad's side married in and we got him back. Willis was going down the road, it's about 5 years ago now. The hitch bin came out of the fertilizer tanks he was hauling. Now in Scott County, we don't have this fertilizer. I'd be shocked if you all had it in Campbell County. I just don't think it's here. It's called hydrous ammonia.
H3.
Yeah, NH3. Do you all have it in Campbell County?
Yeah.
Sorry. But it's everywhere else, and you get on the other side in Ohio, and it's very common over there. The thing about NH3 is when that tank ruptures, you can't see it or smell it. But what it'll do is actually pull the air out of your lungs. You'll asphyxiate, not even have a chance to get away from it. Because you're going to try to move and you don't have any oxygen and you're going to drown out there by that. The tank went in the middle of the intersection. Willis said that he went and stopped at the stoplight and the tank he was hauling went right on by him and into the intersection. Nobody got hurt there. But what's an R key cost? You can get 2 of them for $1 at Tractor Supply. So for 50 cents, Willis could have killed somebody. These are things that I think about in my farming operation. With my farm hands, they find creative ways to break things that I didn't even know existed. My truck has been in the shop for 3 weeks because nobody can understand to look at a temperature gauge on something. For my guys on the road now, I have a piece of chain welded to a hitch pin on every single one of my trucks now. So they don't have any excuse to not find the hitch pin. The hitch pin I have is that fancy one that costs $15 at Tractor Supply, but when you put it in, it automatically locks. So if we cause an accident, it's not going to be because of the hitch pin. Spend the money on the hitch pin. It'll be something else, but it won't be the hitch pin because I can control that. That is the reasonably prudent person. Anytime you cause an accident, you're going to get the foreseeability and how much money it would have cost you to fix that foreseeable event. That's what the law is going to charge you with. Your behavior is judged against that reasonably prudent person. That being said, that addresses, that's pretty easy to say, and then we can get into multiple specific examples for agriculture. But that's what the law is going to judge it against. That being said, tell me about the $10,000 calf.
Well, I had some calves that were getting out, and they came up the hill by my farm. The calf was standing either in the road or right by the road. And my personal feeling is they were probably going too fast, but I wasn't there. I live in Cincinnati. My farm's in Harrison County.
Okay. Yeah.
All right. They said the calf was there. They didn't see it when they came up on it. When they all of a sudden saw it, they veered, ran their car right into the tree. I, in my infinite wisdom, had decided not to get any liability insurance for the farm. So when it was all said and done, the insurance company contacted me for the money that they gave them. I had to pay that. And they contacted me for the balance on the car. I had to pay that. At that time, I got an attorney and had to draw papers that they signed that said, this is it.
Yeah.
Don't come back and visit me in 3 years and say, I got a hangnail from that, and now I need more money. I said, this is all you're getting, that's it, forget it, done. And I ended up, 2 calf crops were gone over it, half a cow herd was gone over it.
Yep.
Try and make enough money up to make it up and take care of it.
And it's a tough thing, isn't it?
Yeah.
Now, I'm telling you about the reasonably prudent person. And we've already agreed that in driving your actual car, is that not a lofty goal? That's just driving a car. In farming, we have anything that can go wrong will go wrong. You will have these days. Yeah, I have these days. It is hard for me to explain to my Louisville born and raised wife about combines and things like this. First time she helped me move equipment, she described the thing I was driving as a Dr. Seuss machine. Which is kind of, I thought, well, that's ridiculous. Like, what are you talking about? Now, she is an attorney. I still don't even like her. But with her Dr. Seuss machine comment, when you look at it, I got stuff spinning and over here, the air cleaner and everything else, and it does kind of look like that. But she provides me a lot of commentary and outside objective work. My wife also did something called subrogation work or insurance defense work. And this is where that's who got you. In a situation like that, what do you do? If the law's going to find you liable for things that were foreseeable, and calves getting out are certainly a foreseeable thing, unless it was an act of God or something that
There was no act of God.
No act of God. What do you do? What do you all do? What's everybody else in this room do? How do you manage that? My insurance. I paid my bill before I left, or after I left work down here. How much liability insurance should we be running? I'll tell you what I have. I have a $2 million policy. I have $1 million, and then $1 million umbrella on top of that, which is good for things other than your farm. It'll protect on your cars and your house or something like that if you have a homeowner's insurance issue. How much do you think that costs? $2 million. That's a lot of money.
That's $400.
$384 is what I paid for
Because
it.
you have to carry it,
Well,
and it's worth it.
is it worth it?
Yeah, I mean, $10,000 would have bought me insurance for probably 15, 20 years.
Yes, ma'am.
Most of us probably have a farm of their own, and we have our certain policy that covers people who are on your property. What good are those signs, really, that you get from, I think Farm Bureau does provide them, says you are understanding that you're aware farm activities take place and there is certain inherent risks to that?
Let me answer your question with a question. Do I have any Farm Bureau insurance salesmen here?
No.
Those signs are worthless. You put them up if you want to. You're only covered in the event of a farm animal liability. I helped write the revision that a couple members of the General Assembly passed 2 years ago that was supposed to help for like a farm stay or a farm activity. But they're pretty limited. You're still, there has not been a case where liability has been quashed based on one of the signs in the notice requirement. Because I guarantee if you ever have an accident, that person didn't read that sign. See how that works? Nobody's ever going to have read that sign. That's just how that goes. Yes, sir.
What does KRS 413.072 say?
Let's look at it. This only deals with nuisance, and I am going to address nuisance when we come back. Nuisance is a different concept in the law versus liability, or negligence is the proper legal term for it. Things that you are negligent, you created a liability upon yourself. That's different than a nuisance claim there. So for negligence and liability, what I was getting back to on the $384 policy that I wrote today, that is your best bet. But always be constantly vigilant on how do I prevent accidents. Accidents are the biggest thing. When you go, every time that I do one of these talks, I go back and I look at the things that I'm doing. I've upgraded lights on my trucks. I'm running LED stuff now. Those lights that were shorting out, and you hit a bump, the lights go off, you hit the next bump, hopefully soon, and the lights will come back on. You all have any trucks like that? Fix that. Those type of things. Be familiar with the equipment moving laws in Kentucky. Now, that is not found in agriculture, but if you're beyond 14 feet, you all realize that you have to have a two-party escort. Somebody's got to be in front of you, somebody's got to be behind you, regardless of the amount of distance you are driving. When I'm in my combine, even when I take everything off, I'm 14 feet. I'm required to have 3 people there to move, legally. I'm supposed to have somebody out there in front, me driving the combine, somebody else behind me. That gate, I can see over the next 2 hills. It's just me. Do I chance it out on the road? I'm telling you not to. But I know what I'm getting into every time I push the throttle forward or the hydro handle forward on the machine.
Are you talking about 14 feet wide or 14 feet long?
14 feet wide.
Okay.
If you are more than 85 feet long, you're required to have that. Now, 85 feet, doesn't that sound ridiculous? Who on earth is hauling anything 85 feet? Now, Dawn has asked me for slides or a presentation tonight. I'm working on that. How many people in here still rate? That's right. 4 hay wagons. When I'm hauling the back of the empties that I'm coming back with, well, that's only 2 trips. I move everything in doubles. I have 24 20-foot wagons. They all have hitches on the back. They're all exactly the same except for one that my dad built before I was born that he will not remove the rigid tailgate on. The rigid tailgate's always the one I forget that's in the middle of the barn that we've just hung the back with, that I have to stop what I'm doing every single year and back that thing out by hand. It's going to find its way in a ditch one day when he's gone. Yeah. Or the tailgate's going to fall off, one of the 2. I hate that thing. It tracks like crap. It's just one of those things. When I come back, it's a 20-foot flat. I've got about 5 feet on the tongue. I got 100 feet behind me. Is that safe? My F-250 Super Duty doesn't mind it. When I'm driving about 15 miles or 20 miles an hour, I have enough brakes to stop it. What do I do beyond that? What amount of swinging out somewhere do I need to get those 16 tires that are behind me there? How many people, if we're talking about that, reasonably prudent farmers, which everyone in here should be, just for giggles one night, why don't you figure out how many tires you have on your farm? I did this a couple weeks ago with a buddy. It was very beer inspired. As many of our discussions tend to be. How many people have had a wagon tire blowout going down the road? Was it your fault? Maybe. Mine have been my fault. I know that. My rotation for wagon tires, the trucks that I run, even the used ones I bought, if it comes with these goofy 17 or 18-inch tires on it, I don't want the truck. I want something that has 16-inch tires. And that's because once I wear that set of tires out on the truck, they rotate and they go into my pool for the wagons. So I know they're old and don't have much tread, but some of this stuff I only move once or twice a year, and the tire looks great starting out. When the tire gets to about 25 miles an hour, it's like an IED hit it. It just explodes because it's so weather checked. I know that. I shouldn't have gone out on the road with it like that. That is my fault. How easy would that be for that tire to blow out and I lose a load because of that, even if the load is secure? Yes, sir.
What if you got a load of bales on your wagon, you're on a narrow road and it's trailing, but that tire goes off the road and blows? You know what I'm saying? It's on the run.
Very good. What do you think?
I guess you're going to be responsible for that tire regardless, but I mean.
Right now, that's just the tire.
It's caused by
The activity that you have driving probably too fast for that. Look, reasonably prudent farmers, now my Cory wagons all have, or should, a little sticker on the front. What's my mile per hour limited to on an implement tire? 25 miles an hour. The implement tire is going to have an SL designation after it. It's called service limited. That's what the tire is rated for. Yeah, which is fine behind the tractor. And then it blows. But if your wagons are so tracked so bad, why are they out on the road? You know they track bad. That's another thing, and that gets into the overhead of farming. That's a whole lot of sunk, dead cost keeping all this stuff up. If you want to go out on the road, you should have to follow the road rules. What is another thing that's coming our way after the bridge laws is I think they're going to make farmers play by real DOT regulations one day. That is going to get real scary. One of my best friends, best farming friends, had to pay a $1,400 fine for going into Illinois on his Kentucky farm tag. You all know why? Ohio hadn't been enforcing that yet. Your old farm plate that's on your truck, what's your pounds limit on it? 38. Unless you tell the county clerk otherwise. DOT regulations kick in if it's a private vehicle at 26. You get 26,001 pound on there, you're playing by full-blown DOT regulations. If it's not farming, if it's just another thing that's out there. That's a big deal. Your farm plate, unless you tell the clerk differently, the clerk in Scott County was just writing everybody for $38,000. It didn't cost anything different. But you are subject to fuel tax assessment when you cross into another state. If you are not bearing the fuel tax collection sticker, that's what they got him for in Illinois. He lawyered up, wanted me to do it, but I wasn't about to. He lost. Didn't pay.
But you have to do 5,000 miles before you're subject to a fuel tax.
Yeah, but this was on his personal farm pickup. Yeah.
So on a pickup truck, he's gonna have to have a portion tags?
He's running a 38,000 pound plate. Think about your old farm plates when you walk out there to it. Does it say 38,000 pounds on it anywhere? It won't. It's on your registration. as to what you know. Now, I've still got 38,000 pounds on everything I have except for one truck, and that's what we go out of state with when I go. I'm an attorney, and I know the rules, so they will have no mercy on me when I get pulled over. But I still frequently retrieve equipment very early on Sunday mornings. I have done things like that. The very first combine I bought in Lancaster, Kentucky. Y'all ever been there? Y'all know where Rupp Arena is? Lexington? That is US 27 right beside it. When I drove that thing home, I drove it up right past UK's campus Sunday morning, right by Rupp Arena downtown, and I drove it into the farm gate. I've done things like that before. The last thing that I hauled home was 1,600 miles away. You don't have enough Sunday mornings to get 1,600 miles in the belt, but the rules are still applicable. Now, these are very real things that are coming your way, that in my mind. Because you are engaged in a commercial activity, the same as a trucker is engaged in a commercial activity. The thought process is, because you're an agriculturalist, explain to me why you are allowed to be less safe than the other people. That is what the proponents of something like that are saying. As agriculturalists, we're saying, we drive so few miles, 5,000 miles or less. I can fill out a 943 with tax exempt on that. But think about what the other side is going to say. They're going to say 5,000 miles or 50 miles, if you cause an accident, you caused an accident. That's something I think is coming away. That is the negligence versus liability argument. Reassess and constantly reassess your farm safety. That is one of the easiest ways to lose a farm. If I have a few minutes before we quit tonight, I'll explain in my mind the most expensive, or the biggest piece of farm equipment in terms of liability, the biggest piece in terms of importance in your life. I'll leave you with that teaser until I get to it between now and then. Yes, ma'am?
To return to another commercial aspect, in this area, more of us are going into agritourism. How do you see that affecting what's going to happen more about that? Because we're so liable for activities.
Full blown. I think you have full blown liability. I don't see any limitation. I don't pick up the law journals and read any cases where I think, wow, I am shocked by how small that jury amount is. You'll see what I'm saying? I don't read cases where I'm like, wow, that was a really low amount they allowed that person. Usually it's the exact opposite. And then usually I'm wrapping my head around, oh my gosh, they found that person liable for that. I do that all the time. Well, it's just some of those things. We're in such a litigious society that short of some sort of meaningful court reform, I don't see that balloon getting any smaller than it is right now in terms of exposure to liability.
So when you talk about your $2 million liability policy, does any of that cover people on the farm?
Very good. Does it? Mine does, because I have specifically read my policy.
Your insurance company?
Farm Bureau. I've got Farm Bureau. But it doesn't matter that it's Farm Bureau or not. Read your insurance policy. I have this sinking sense of loyalty to my neighbors, and I go and help them out frequently before I'm done running corn. This past year, I ran corn for my neighbor that has organic corn. And he got in a pinch and really needed it, and I had 300 acres left. And I thought, no, I'll go run it for the neighbor. Traditionally, if you leave your farm and you're going to go run custom, that can be an out on your policy. If your piece of equipment hurts somebody, that's not you anymore. You're into the big boy realm there. So make sure you get a rider on that. All I had to do was tell my agent, occasionally I go do some custom work. Is that okay? And the agent said, well, yeah, let's just write it into the policy. So that happened. Of course, I go over there to run his corn on some of the very few nice days we had in the fall. He had so many weeds that it wrapped around my straw walker cranks, and $4,000 later, I was back in my fields for 2 weeks and $4,000 for, and it didn't even fill up the tank on the combine, which is the most annoying thing. So he did buy me a lunch. I never told him how bad it got, but he's a great neighbor, and that's what we have. Those are the rules there. Constantly reassess your all safety plan. Have a safety plan. Does anybody still raise tobacco in here? I could give you the rest of the night on liability. I thought that I had a pretty good safety plan until 2 years ago, not this past year, the year before. I had a man fall out of a tobacco barn. The rail broke because of carpenter bees that had bored into the bottom of this rail. I'm meticulous about our tobacco barns. In our area, a tobacco barn goes between $4 and $6 per rail on rent. Sounds pretty good, right? It's a lot of money for a tobacco barn. But I have spent a significant amount of money stiffening those things. I've got runners in every single rail. Rail still broke. The man hit that trailer and couldn't move. Called the ambulance. The ambulance is on his way. ¿Cuántas personas aquí conozcas? Es muy importante hablar español con tu rancho. Anybody?
Very important
What?
to speak
I'm not even sure if what I said was all correct. That's my Spanglish that I have managed to put together. But it sounds good, doesn't it? I asked how many people in here think it's important to speak Spanish on your farm. You all have Spanish employees or native Spanish speakers? I do. And I thought my Spanish skills would be good enough to communicate with those folks. Prior to that moment, they were. Usually because they slowed way down for me and used vocabulary that they knew I was comfortable with, and we got along great. And somebody's screaming at you in pain, are you going to be able to understand it in English, let alone Spanish? I failed it. That was a foreseeable thing, that I should have a backup plan. Telling the ambulance where I was tricky. Gave them the address of the farm. The farm has a couple entrances, and they're both hard to find. I had to actually send a man out to the road to flag that person down. I hadn't thought about that. All of your gates marked. If somebody's in a bad accident, do you know how you're going to get the ambulance there? Can you even physically get an ambulance to where you're all going to be working? That's awful. I mean, this was awful. They carted that man off to the hospital. The next week, we're back at it. Another rail broke. So in 2 consecutive weeks on Saturdays, I sent a man to the hospital. This guy didn't move until the ambulance guy got there. I thought he was paralyzed for sure. Same thing. That has cemented the fact now that when I'm working somewhere, everyone in my crew knows where we are. The Spanish-speaking guys that help me, the crew leaders, they all know where we are. And we've got a marker or a flag or something out at the front to where we are to know. That is part of being foreseeable. You all have chains and straps and R keys and hitch pins going down the road. Carry a backup, carry a spare. You all have a slow-moving vehicle sign on the back of everything that is slowly moving going down the road. Well, it was there. Can you still see the slow-moving vehicle sign? Maybe. You got a rag? We'll see.
Of course. That orange rusty.
Yeah, that old, like galvanized looking thing there, there's supposed to be a sticker on that? Absolutely. Do your lights work on your equipment? I'm talking about on your actual equipment, the tractors. Flashers all work? Think about that. Those are some other things. We are clicking. We can talk about that the rest of the night, mostly to scare folks into going and reviewing your policy. Insurance is a good way to take care of a lot of your liability, but that is not the be-all, end-all. My grandmother, for most of the latter part of her life, lived in the old people community behind Walton School. So just right, hop, skip, and a jump away from here. When we finally did have to take her to the nursing home, on the way to her room in the nursing home, there was a 17-year-old kid in the room prior to her that had been in there for almost a year. That kid, the nurses were talking about, required $17,000 a month in medical care. How fast is that going to eat $2 million? After that $2 million, what other assets do you own that you're going to be able to pay or sell to pay for that boy's care? Now, I don't know what he was in there for other than a car accident, but it's easy to do that to somebody. So let that sink in. Let's talk about nuisance and planning and zoning and things like that. This is what we all actually came here for, to talk about that. So we need to know first, before we even get into 413.072, what is a nuisance? As part of your little lawyer kit, in law school you get to go buy about a 4-inch tall book called the Black's Law Dictionary. Or at least I had to. And now they got all this stuff online for free. So, if you all do have any questions about what legal terms mean, legal terms can be really tricky because it means exactly what that is. So as attorneys, we pick very specific keywords to describe something. So when you talk about a nuisance, that is an actual very, very small carve-out in the law. That is not liability, it's not negligence, but it is a related concept. Liability and negligence are tort concepts. Nuisance is, if you have two Venn diagrams, you know, the two spheres and they overlap a little bit, the nuisance is the shaded in spot where the two overlap that have to do with property and tort. Nuisance stuff, generally speaking, through the law, involves use of real property. It can involve personal property. So a nuisance, defined as Black's Law Dictionary, is anything that, this is another reason why people hate attorneys, worketh. That, I mean, it sounds like I'm authoring the Bible. Anything that unlawfully worketh hurt. Now they can't say hurts you. Worketh hurt. Inconvenience or damage are the class of wrongs that arise from the unreasonable, unwarranted, or unlawful use by a person of his own property, either real or personal, from his own, and well, there's the rest of the thing. You probably have to pay and read that part. It's when you're inflicting some harm, generally speaking, to your neighbors or others. It doesn't have to be a direct neighbor. There was a handout when you all came in the door. I'm going to go back to the right to farm, as it was titled, legislation. But there was a good handout when you all came in, and I grabbed one, and I have a couple of other thoughts on it. So we know what a nuisance is. And in agriculture, we're generally speaking about the things that you're doing on your farm that may be affecting others, including your neighbors. I'm dealing with a very big nuisance lawsuit right now in a county that has absolutely zero zoning. It's a rendering plant that is located 9/10 of a mile from a school, and it's a startup. And rendering operation that they have is that they pick up dead bodies and they render them into proteins that are saleable in the animal agriculture industry. So feed additives, foodstuffs for other non-bovine species, fish food, and then they also make bone meal and things like that. And then from that, people make cosmetics and a whole other line of products. What nuisance do you think is coming from a rendering plant? Smells. Some odors. What? Now there's none of them. there's the sight of a nuisance. And it can consider a sight of something to be a nuisance to you, that it would gravely offend a person.
Animals lying around, that's good, that's why.
Dead animals. In high school, the best looking girl in Scott County High School at that time was a girl named Jessica Richardson. I sat next to her. Her name was not Jessica Richardson. We're recording this. If there was one, let's call her something, Jessica something. Well, I had my eye on her. She did not have her eye on me. Sat next to her in English. And she knew who I was, and that's back when every boy's going to get their pickup truck or their car. We're going to all get to start dating. So I'm in my pickup truck the first time Jessica sees me out in her car. We both pull up to the stoplight at the middle of Georgetown. She looks at me and smiles and waves, and then Jessica looks to the back of my truck and just an appalled look, like she was going to gag, comes over her face. This was in February, and I was hauling a very frozen steer to the diagnostic lab. I had all 4 points sticking up in the back of that truck. That sight very much offended Jessica Richardson, and I'm convinced that's the only reason we're not married. But some sights can be offensive to other folks. Smells are a very real thing in ag. Smells are huge, and not all of them have to do with dead animal odor. There's some other animal smells that come from farms that they smell good. One of my very closest friends has the largest hog operation in Kentucky. When I say it's big, it's big. They have at least 1 tractor trailer load of pigs that are finished leave every single day of the week. Every day. They're huge. Your all's feed mill where you buy feed from, think about how big that is. It's not as big as this one. They have the biggest feed mill in the state that sits on their property. When the chicken houses lost feed a few years ago due to the flood, the poultry operation in Kentucky used their facility because it had so much extra capacity to make feed. It is a very, very big outfit. That place produces all sorts of smells. They have manure smells, and then they have smells of the actual pigs themselves. Chickens and cattle, dairy cattle included, also produce some smells. Now, whether they're confined or not, they produce an odor that some people consider to be offensive. Now, sometimes this odor is concentrated in a barn that these things they live in, and then it exits through a fan or a vent system. And that's a way to concentrate a large group of cattle into 1 or 2 very small openings, and you're jetting it towards somebody. That's an offensive smell. I have personally had 4 government agencies respond to my farm 3 years ago for a chemical outbreak or attack. And it is because I was spraying my tobacco crop after I had topped it with a product called fatty acid. For those of you that grew up on tobacco farms, you're probably familiar with MH30, sucker control, Prime Plus, the Butyl, and the other products. Now I don't have to use any of those chemicals. I can use a fatty acid. It's an oil, just a fatty acid. It runs down the plant, and it comes into contact with where one of the little buds were, and just burns it out. This stuff, to me, it smells like cooking oil. The grandmother next door called EMS, and they sent out the EPA, the water control guys, the air quality guys, and the sheriff's office. All came out there to visit me because she was repulsed by this smell. Now, you use a lot of this product. You are using 50 gallons per acre. So when I load up my highboy, I get 4 acres out of that. So you have to use such a volume. And it does smell. It got hot on that day. So it is cooking oil sprayed outside that is warm. When I was there and the the sheriff was interviewing her, her kids, her grandchildren that she was watching, said that they loved the smell because they thought it smelled like McDonald's. So you have varying degrees. Even within the same bloodline, you have a lady that was repulsed and called the law, and then you had her children that enjoyed the smell that came from that. In that same vein, are you all familiar with the chemical 2,4-D? I can tell you if anybody in Scott County within 5 miles of me is spraying 2,4-D, because I think I have a mild allergy to it. That smell, to me, is an awful, awful smell. I hate the smell of that chemical. It doesn't bother most people, but you know that smell. It's just a very unique smell. If I spray my chemical and that 2,4-D is evident through air smell, but not contact with plants, have I bothered my neighbors? Have I caused them damage, is whether it's warranted or not? Did I mean to? What if I went out there and sprayed and a front is coming through, or it was windy and stopped and it just volatilized? That's what happens there. It's not enough to kill something, but it's enough to make it drip. I didn't mean to do it. I followed everything. I looked at the forecast. But I caused an unreasonable smell for my neighbors. We'll talk about that in conjunction with nuisance. Yes, sir.
Does it matter whether the farm was there before the house or the house was there before the farm?
213-072 is Kentucky's attempt at a right to farm law. They do make a distinction between you coming to the nuisance and the nuisance coming to you. Forget about that. My activity, did it cause my neighbor discomfort? That's what I want you to actually think about. Whether or not you're in the right or wrong to do something, I have still caused my neighbor some displeasantness in their living because of an action that I performed. So we'll come back to whether or not you've moved to it, and my answer might surprise you. I don't think it matters. Whether you move to it or not, you're still performing an activity that causes harm to your neighbor. And just because you grew up next to it or you're used to it, does it make it any less offensive for the person next door? Maybe, maybe not. Yes, sir.
There's no way it's coming out of the same category?
Very good. Noise. That's actually, well, it's further down the list, but sounds. Well, we have a lot of sounds in ag. My neighbors in that house growing up lived, it's probably about 2/10 of a mile. And they have walnut trees in their yard, same as I have walnut trees. And these people mow their yard like it was a golf course. Well, every year in November, these people would be out there mowing, and they would get up at around 5:30 or 6 on Sunday mornings. Their church they belonged to met on Saturdays. So Sundays they would get up real early on their riding lawnmowers and go out there and start hitting the walnuts that were on the ground. They would never pick them up. But they would launch those things against plank fence that surrounded their yard. And I could hear that stuff at 6 in the morning on Sundays until they got done. That was a nuisance to me. Farmers create other types of noises. We have a lot of noises that come from our livestock. That's a very big nuisance complaint now. There's a growing trend in ag circles to have cage-free animals, chickens, free-range things. We get those things outside of a building, they are loud. If you have them in any kind of concentrated numbers, they create a nuisance. Backyard flocks, backyard chickens, that's a very popular thing. I'm dealing with somebody in Louisville right now who has racing pigeons. And he has, I don't know, a couple hundred racing pigeons in his backyard. And pigeons is an actual approved species of bird to be considered agriculture under poultry in Kentucky. So that's why I'm trying to defend his right to racing pigeons through use of poultry. I'm dying to know everything there is to know about racing pigeons at this point, because I'm wondering if they're wearing little silks while they're flying. Are you familiar with racing pigeons? Well, that's all I can say about this guy, because I need to know everything about this. But that is something that is causing discomfort to his neighbors, because the things are apparently pretty loud. And they're up at hours of the night making noises, according to his neighbors. This guy is saying they're loud during the day a little bit, but not at night. That's how he described it. So there's a noise component to this. The noise that I have made is running a disc mower loud. Not really. Hit a few rocks, they can get kind of loud. Winding noises, people can deal with it. During the day, that's fine. Those 300 people that I live around their subdivision, this year I got the corn out whenever I physically could around them. I waited forever, so I wasn't going to be making ruts that I'm going to have to deal with for years on the farm. So I would wait until the ground was froze. When the ground was freezing, I was out there regardless of what time it was during the day. It was not uncommon for me, not on purpose, but I was out there running corn until 2 or 2:30 at night a few times. Is that unreasonable to my neighbor? Yes. It may be. Absolutely. Now, in my defense, was I taking advantage of the windows that I had to actually get the corn out? Does that make any difference? Is that, well, the neighbors that I woke up, did they think, oh, well, he's getting the corn out. He hadn't had a chance. He's got a lot of other jobs, and so, you know, getting this corn out wasn't real high priority, and he could have done it yesterday when it was froze, but he had a meeting to go to. You think they cared then? No. But I caused them a great deal of discomfort from a noise situation like that. I have a neighbor in Midway, Kentucky, that farms pretty close to a subdivision, and he put in a grain system last year to replace the old one that he had. The old one that he had 3 horsepower centrifugal fans. I'm sorry, squirrel cage type fans. You'll probably see them in your mechanics places. They move a lot of air slow. That's what he wanted. In this new grain setup, he has a fan out there that has a 25 horse electric motor on a centrifugal fan. This thing sounds like a jet engine starting up. He's got a small engine to even start the big engine running, so that the giant jumbo jet can start up and start drying his corn. There are neighbors that are talking about being able to hear that thing from 4 miles away. Our neighbor growing up had an irrigation outfit that he had made out of an old 390 gas Ford motor with headers on it. And I knew when he was sucking out of the creek, and that was 2 miles away from our place. Most people, you'll remember back irrigating tobacco, once you started, we would run for 23 hours out of the day. Because of the way we had our pipes set up, I could run that long. And I got to go to bed between 6 and 7 in the morning, and I'd help my dad move the elbows to start the next set, and then I got to go home and go to sleep here today. Again, from an ag standpoint, is that reasonable? From my perspective, it is. If I caused an immense amount of discomfort to the neighbors at night, that's what I did. So is noise a nuisance? Absolutely yes. Dust is another one. How many people in here still work ground? I do. I raise it back. I still work ground. When it gets kind of dry, the ground needs going over, I will raise billowing clouds of dust. Don't mean to. Try not to work the ground when it's like that. Sometimes you have to incorporate fertilizer or the chemical that you just put on it. That dust, when it goes and lands on somebody, is that a nuisance?
Yes.
Could be. If I have a chicken facility and my fans are on, particulate matter are leaving those fans. They will accumulate and rest on neighboring houses, cars, things like that. Is that a nuisance? Probably. Michael's bin system on the unloader If you're all familiar with corn, there are these things called bees wings on the bottom of every little piece of corn. They have two little butterfly-looking pieces of the rhinoplasm for the plant, or at the very bottom. And that thing can stay on that corn. You can handle that corn 1,000 times. On the 1,001st time you handle it, some of those little bees wings will fly off, go accumulate somewhere. He's had to put in a collection system for his to try to limit the bees wings for a neighbor that was 4/10 of a mile away that this was landing on. That neighbor moved to the nuisance, but Michael upgraded his system over a very slow system where I guess the bees, it wasn't as aggressive on handling the corn. It didn't come off in as great a volume right then. So did moving to the nuisance make any difference? If the farmer, in order to keep up, upgraded equipment and made the nuisance worse? That's why I'm saying it may not matter. There's one other thing that the law does provide good guidance on for nuisance, and that's chemical usage. If you are spraying a chemical and it gets onto your neighbor's property, you are absolutely liable under Kentucky law for that overspray, that drift case. I help prosecute is not the correct word for it, but I help legally administer the fines that go with that. We have had fines that have been upwards of $100,000, where a drift case from 2,4-D drifted in, and 2,4-D kills everything except for grass crops. It's broadleaf killer. This broadleaf killer drifted into a man's nursery operation and killed a whole bunch of trees and small stock. Ended up costing several $1 million worth of nursery stock, and the lawsuit for that is still ongoing. It's a very, very big case. Now that thing, even though that is a nuisance, we do have firm things on it. Yes, sir.
What about if you have power lines across your land, and of course, trees and shrubs and stuff that, you know, that they will clear out from under the lines?
Right.
Well, they come through with the helicopter and spray.
Okay.
Are they liable?
Yes. If that spray drifts beyond their easement that they've purchased, owned, possessed, leased, whatever, then yeah. Yeah, they could be. Absolutely, in a chemical situation. Yeah. Because they're only allowed to utilize or control whatever they have there. Now those are the big ones. You do have two emerging areas of nuisance that are coming down, and it's damage to common use places or facilities. Typically, this is a lot of weight on asphalt roads that are destroying the roads. That is a big, big deal. Now, again, you might be in the rural community, or you might have just moved there, but the entire time growing up, the very first day that I got my driver's license, I was driving a 2-ton, well, it might have even been the bigger truck, essentially a semi-truck size, hauling corn that afternoon. I was dumb. I will never let my son do that. But we were pinched for help, and that's what we had to do. So I'm driving big trucks, tandem axle trucks down the road. The road supported that weight. Once I started farming, I struggled with these little tandem axle trucks that my dad loved so much for 1 year, and that was it. I had enough. My time is valuable, so I can be in the truck and I can either be hauling 300 bushels at a time, or I can be in the truck and I can be hauling 1,000 bushels at a time. I'm going to do the 1,000-pound route. When I did that, the weight increased exponentially. I know this even going in and out of my farm driveway. I've put a lot of rock back in my farm driveway because I have mashed down what I had been over thousands and thousands of times with the other trucks with. My weight destroyed our farm roads. I had to fix it. That's me. That's my dollar fixing my roads that I've made bad ruts on. And when I pulled out on my county road, who's fixing that? The county, when they get around to it. What about the other damage that I have caused for that amount of weight on either a poorly constructed road or a road that just, I am putting more volume on it, traffic-wise, than it's probably designed for the amount of fill that they use. So damage to common use areas is something big, and then the kind of the last emerging area of nuisance is water usage. My neighbors have put a pretty big pump in underground, a well, and when they start irrigating tobacco out of their well, the city of Georgetown can notice on the creek that feeds the municipal water system there, the amount of pull that that thing has on the system. That's how big that is. So the farm is creating a hazard, and that's just him. I want to find a well. I paid to have, I think you get 3 test wells for the amount of money, and they couldn't find it anywhere on me, but I can look at his well, and he's got it. So maybe I have a bad driller or something. Look. But that is another very real thing. Part of ag operations now, how nice and easy is it to tie into the sewer system if it's available? We bought a farm last year that is on not only city water, which is great, but it's also on city sewage. That farm, prior to it being put on city sewage a long time ago, was a horse farm. And all of the drains on that thing, for those stalls and everything else, are now plumbed into that sewage system. Do you think that that county municipal sewer system, or my Georgetown city municipal sewer system, was built to design, or built in the design phase to carry the storm load off of that, let alone actually having the horses out there? Am I creating a nuisance from my farm activity that's been there forever by simply tying onto that pipe? It's a zoning issue that can arise. So when we talk about nuisance, we're talking about an activity that reaches some sort of threshold where it goes beyond a mere inconvenience to your neighbor and becomes something that does either physically, mentally, or mechanically harm them in some sort of form. Usually it takes a judge or a jury to decide where, yeah, that's kind of annoying to be out there at 6 in the morning doing those walnuts against the tree, versus no, I can smell your operation for so many weeks out of the year. You cannot do that. That is a nuisance, and you're harming me by your farming practice. There's some sort of threshold or break, but from this point, let's just assume you are creating a nuisance. 413.072 is Kentucky's attempt to regulate or to provide farmers some protections when they do hypothetically, unknowingly, or unwillingly create that nuisance through their actions. This thing says, and your point was very well taken about who created the nuisance to begin with. This thing says no, in number 2, no ag or silviculture operation or any of its appurtenances shall become a nuisance or trespass. Yada, yada, yada. That's what you wanted an attorney to say, right? All that other stuff is crap in the middle. If the ag operation has been in place for more than a year, which basically says if they've been out there doing this practice for a year, it shouldn't just suddenly spring to life and become a nuisance. We're going to protect you, farmer, against that. That's what the thing says. Now, what if you were out there and this guy's been operating a dairy for a century, that farm did, and you buy that farm next to him and subdivide it and now have 13 common neighbors with him? Did you move to the nuisance? Yes. The law here is attempting to say, hey, you shouldn't get to sue on that. It should limit your right. The problem with it is we have a very strong plaintiffs bar in Kentucky. Trial attorneys. They do a lot. Anytime that we attempt to limit how the breadth of somebody's ability to recover, you have some very vocal advocates that prevent that from happening. You're only stopped from filing a nuisance if the farmer is doing a non-normal practice, an older practice. You get full bar. You can go after it. Now, if the farmer is doing a normal, commonly accepted practice, you're also supposed to have some limited liability there. But what is normal and commonly what is a good ag practice? Back up and say that. Well, a good ag practice in and of itself is one that does not cause or create a nuisance. The reasonably prudent farmer isn't going to be out there creating a nuisance for his neighbor. So if you're balancing that against what a good common use farming practice is, then you should be safe, right? You're
Who's
getting
gonna
on a
spread that manure?
treadmill that doesn't stop.
Who's gonna spread that manure?
I don't know. I've been offered 400 tons of dairy manure that's 7 miles down the road from UK because they do the CEC requirements. And this is something you need to know. If you have manure right now, your ag water quality plan, you are limited on how to do that. They physically need ground to go spread this. I haven't accepted this stuff yet because number one, I don't know how I'm gonna go get it all. And number two, I'm up against those subdivisions. What do I do there? Now, what is a good common use on manure now? 50 years ago, how would we deal with dairy manure?
Just spread it on field.
Pump it out, bring in a vacuum tank, pump it out of the lagoon that is generally kept in, and I'm just going and spraying that on top of the ground. If I'm that person's attorney, what am I going to say? Am I going to say that's a common ag practice? But is it a good one? Is that a sound ag practice?
No.
Not when it's technically feasible for me to go inject all of that stuff out there. That is the technological treadmill that this thing doesn't take into effect. Now you're talking about having the wind knocked out of your sails on that. This is another one. I don't know how good this thing is. We, to date, well, as a couple weeks ago, there's not been a significant challenge that has been tested in court that has used 413 as a defense on a nuisance claim. Most of the claims that have taken place under 413, 072, have involved pure zoning issues. Now, there is something in here that says if you have anything that comes in conflict here, your planning and zoning board is shot down and it's null and void if it conflicts with this. The only cases that I've had on this is where somebody's built just essentially a really big barn on their property, or a shed, or a machine shed, or a shop or something, saying, oh yeah, that's for ag. Well, why do you have a whole bunch of old race cars? Or you're restoring things in it? Is that agriculture?
No.
Well, I built it as an ag shed. Really? Why'd you do that? Well, it's taxed differently. See, it's taxed at a much lower rate if I built it as ag. And I was going to use it. I parked a load of hay in it once. I've seen that as an actual legal defense. In Western Kentucky, a man he borrowed a load of hay, parked it in his barn and said this, and took pictures and showed the judge later on. Now you can imagine the judge is real keen on that, right? Because the guy he's setting out, and he's being completely honest, but he set out to game the system, and I really wish he had won. Just because I enjoy an underdog fight on something like that. The judge shot him down in that. But the planning and zoning people had zoning requirements and other requirements that came with even construction of the shed. There's permits that are required. In that county, if you claimed it as ag, it's hands off. Didn't have to have an inspection other than making sure that with your drop line, I think you have to have a single outlet, right, and a switch or something. That's all the electrical inspector needs to have. That was that. But that is the nuisance law in a nutshell. There's none of this. There's none of these things that are going to be a silver bullet to protect you in what you're doing if you are indeed creating a nuisance and you haven't gone through that analysis that goes with it. That is, how much is the potential harm that could be created out there, and how little would it cost me to do that? The thing with Michael and his bees wings situation is he's got a cyclone kind of thing there at the top that helps the grains spin out the bees wings. That thing cost him $1,500 and he installed it. His giant fan that he put on there, for $500 he bought a muffler kit for it. And it kind of looks like a giant muffler. It's got baffles in it. But it has taken the sound of that fan down to where if he's around his bin site, I can be on the phone with him. The nuisance he was creating then was easily taken care of with a relatively small investment. But that's easy stuff. How do we get rid of the manure and it not smell? You have injection things available to you. Beef manure, I don't know what you're going to do there. But some of the thought is, well, when are we going to spread it? Let's go do it when it's cold out, but not during 100-degree heat, where you're going to encourage some additional smells. The dust and the chemicals and the sounds thing. Am I creating a nuisance for my neighbors by running late at night? Yeah, probably. I should try not to do that. My nuisance abatement plan there involves, if I know I'm going to be running late, during the day I go over there and I run until about 9 o'clock, so I think that's fair, towards the subdivision, but I've got other ground over here on the other side of the hill that I go try to hit at night, if I can. And usually that, when I think about it, it works out for me too, because over there's the hardest to get to anyway. The ground's good and froze at that point, I can get in and out easy. It's worked out. If you are creating a nuisance, though, I can tell you, even if you're right, even if you prevail on one of these things, you're still going to have to pay your own attorney's fees for a defense. So even if you can possibly win on one of these, you're still going to be out money on it. I don't know how much other overlap you would get given the time that we could get into the nuisance and zoning. I'll come back to the most important thing on your farming operation and the thing that creates the biggest amount of liability if you want. Think y'all have time for that? What do you all think is your single most important piece of farm equipment? Personnel? Not mine. Mine could break animals. It's amazing to see some of the things they broke and then their explanation for it, because nobody ever sees anything. Nobody was ever driving it either. It just broke. It was sitting there and it just broke. Anybody else? I guarantee everyone in this room, pretty well has one. It's one of these. This is your most important piece of farming. If you don't have one, get one. If you do get a cell phone, now right now, I've not had a signal since I've been in here. You all have one? No? So if you're farming and you know you're going to be in a remote location, you have people working for you like I did to fill out the tobacco barn. If I've got a cell phone plan that doesn't cover where I'm going to be working, how good is that? Not very. And do I have a way to communicate with somebody else? These things are great. They're great for informing your other farmers when their cattle are out on the road. They're good for market reports, updates. You can look at the laws on this. I check the weather 5 times a day. I get market reports with it. It's fantastic. Everyone in here should have a functioning cell phone for where they're going to be farming. That being said, I've got a couple farms that the cell phone works, but I got to be right, standing in the right direction, and have gone to church.
And the
sun has to be facing everywhere, because it sometimes works, and I know where it works, and I can take care of that. The last thing that I'll tell you, if we are going to think about being the reasonably prudent farmer, and especially with my thoughts on bankruptcy, is the biggest piece of farm equipment when it comes to liability. The easiest way to lose a farm when it comes to farm equipment. Any guesses on that? Not livestock? Nope. Four-wheelers? My dad never let me have a four-wheeler growing up. I'm still bitter about this. My dad thought a reasonable alternative was to buy a go-kart. No, it was an easy-go. It was from a golf course, and it had a little bed in the back of it. It was an electric-powered go-kart. I ran over my brother with it and broke 5 of his bones. So Dad, the older I get, man, he keeps getting smarter. It's funny how that happens. Anybody else want to venture a guess on your scariest piece of farm equipment?
Can I say something on this for a second?
Sure.
A lot of the fellows here are a little bit older. If you're over 65, this is free. You are aware of that?
Yes.
Okay. I thought maybe they should hold that.
Does it work where you're farming?
Yeah, I know.
Oh.
But I've got 2 of them. I have another one in the other pocket. I just take drug deals on this one.
That's good. That's why you need 2 of them. He's probably not your county the thing that I have personally witnessed removed farms from people that had been in their farms for generations and generations. There is one piece of farm equipment that one false move will rob you of everything you own, potentially. No, it's not that. It's one of these. Do y'all have them? I'm not joking. Think around. Think about it. I've got one. My biggest farming competitor in my neighborhood, his wife and I went through the Ag Leadership Program a couple years ago. Traveled, got to do all kinds of things. She shot me a text message today that they're getting a divorce. I'm guessing this divorce is going to cost that man 500 acres. Gone. I know he's got $3 million worth of relatively late model John Deere equipment. $1.5 million. Can you all afford that? Can you afford to lose half of what you have right now and then be able to repay the loan you need to keep with only half the assets, the working capital that you have? One of the by far nicest farms in Scott County that happened to, it's no longer a farm, it was bought by, well, it is a farm, it was bought by some horse farmers. The amount of liability that caused that man was the waitress at our Jerry's restaurant. Caused a farm that had been in his family for 4 generations. Be gone. I really do. I try to tell people this because it's not all about just keeping all your limbs and digits and fingers and everything intact. There are some other things there, and I'm telling you all the things that I am cognizant. I know better, and it still sometimes happens. But every one of you all in here can do a better job on that other because I'm never home. I mean, my wife's going to get real tired of that one day. And she's also real tired of repair bills that we get and these explanations that we have for time. She's ecstatic when I spend this amount of time away from our 2 very small children. We have a 4-month-old daughter that had something called colic. I didn't know what colic was until we had that one, because the first child is fantastic. I guarantee if the first child had had colic, there wouldn't have been a second. My nerves can't handle this. But not being home and not cultivating that other relationship you have with your farming partner, good way to lose a farm. Thank you all. This has been great. I didn't cover nuisance quite as in depth as I thought I would, but remember, if you are in a nuisance situation or you think you're going to have one, go back to that thought about negligence and liability of the reasonably prudent person, the reasonably prudent farmer. I bet you can find some way to lower that amount of nuisance that you're causing with your neighbor. Again, on a nuisance action, if you're creating one, it is the exact same thing as we can wrap back to the very beginning, is if you ever have to sue your neighbor or your neighbor has sued you, you've already lost something. You've lost a very long-term relationship that you can have with one of the closest people that you can have in terms of a farm ally, whether they farm or not. I hope you all have a great evening. I hope we have at least a 10-point cushion throughout the rest of this day. And if you all need me, Don has my email address, and love to talk to you all if you have any further questions in the future.
Thank you all for coming.